A person asks for money. The first answer is no. The person leans closer, repeats the demand, and speaks in a rough, partly inaudible way. No express promise of violence is heard. Can that still be a threat of violence for robbery? The evidence came from an incident at Hamilton bus station at about 6 in the evening. The complainant said Broughton approached with another person, picked up a radio from the table without asking, examined it, then asked whether the complainant had any money. The complainant said the first request was refused. Broughton then persisted, leaned forward to about a foot from the complainant's face, spoke roughly, and mumbled something that could not be made out. The complainant handed over $5. The complainant said this was because the conduct created the impression that violence would follow if the money was withheld. Broughton faced alternative counts of robbery and theft. After a legal ruling against the Crown, the District Court directed not guilty verdicts, so the ruling could be challenged by case stated. The appeal therefore concerned a point of law. For robbery, the provision applied in this case required a theft accompanied by violence or threats of violence, used to extort the property stolen. The dispute centred on the quality of the alleged threat. The court gave the words their ordinary meaning. A threat of violence is the manifestation of an intention to inflict violence unless the money or property is handed over. It may be direct or veiled. It may be conveyed by words, conduct, or a combination of both. The actual presence or absence of fear is not the yardstick. The inquiry does not turn on what the court called the strength of the nerves of the person threatened. The focus is the conduct of the accused and whether that conduct itself conveyed a threat of violence. Conduct must be assessed in the context in which it occurred. The court identified all the circumstances, including the parties' relative ages and physiques, appearance and demeanour, what was said or done, and the manner and setting of the incident. The assessment is one of fact and degree. Applied to the deposition evidence, the court considered the setting, the repeated demand after refusal, the close leaning, the serious presentation, the rough speech, and the inaudible muttering. Taken together, that evidence was capable of being regarded by a jury as a threat of violence. The court answered yes. The evidence was capable of being regarded by a jury as constituting a threat of violence. But that was not a finding of guilt. It was an answer to the legal question raised by the case stated. Although the court had power to direct a new trial, it declined to do so. Given the elapsed time and prior proceedings, a further trial was not considered to be in the interest of justice. For investigators, do not ask only, was the complainant afraid? Record the exact words, conduct, proximity, manner, setting, and surrounding circumstances. Then ask whether the accused's conduct, viewed as a whole, manifested an intention that violence would follow unless the property was handed over.